All right, this video lecture is focusing on malpractice ethics within social work. This kind of mirrors some of those legal obligations that we talked about in last class that kind of set the stage that we need to know what we are legally obligated to do within the profession, because malpractice comes in when those legal duties are not upheld and some sort of harm has occurred to our clients. And so this is an unfortunate topic to talk about. It would be really great if we could be like, nope, we never cause harm to our clients. We are wonderful social workers and we care so much about humans. But unfortunately, this does exist. And it's something that you have to be aware of, especially with those legal duties, because even as we learned, acts of omission, so not doing something, can still hold us liable, even though we might not have done intentional actions. And we're going to talk about 3 different types of malpractice within this, and that will kind of hopefully make a little bit more sense. But you need to know this because no judge is going to care if you come up in front of them and say, well, I didn't know I was supposed to do that. Well, you should have known as part of your duty to the profession, and so here's your opportunity to educate yourself. So, malpractice defined by our good friend Reamer is defined as a form of negligence that occurs when a practitioner acts in a manner that's inconsistent with a profession standard of care, essentially going against the way an ordinary and reasonable and prudent professional would act under the same or similar circumstances. So, we've talked about the code of ethics all the time, and so that's setting that standard for expected professional care in behavior. And so malpractice comes when you deviate from that established care in a way that then ends up causing harm to our clients. So when malpractice occurs, a person or a group may file a lawsuit in civil court, not criminal court, it's civil court. There is a difference between the two. And they do this on the basis that injury or suffering has resulted because of the wrongful actions or inaction of the professional person. And so the plaintiff in these cases are often the client or a member of the client's family who is filing on their behalf. And they're typically seeking some sort of monetary damages to compensate for injuries or suffering that occurred because of the professional's either action or inaction in a certain situation. So in order for malpractice to occur and be present, there's 4 elements that have to be in place. The first one would be at the time of the alleged malpractice, there has to be some sort of legal duty. So those duties that we talked about in the last class, they have to have had existed either formally or informally between the practitioner and the client. So it can't just be like, I'm a social worker, I broke confidentiality, and so somebody heard about it, and then they're like, well, I'm going to sue you, but they weren't my client. No, you have to be in some sort of contractual, again, doesn't necessarily have to be signed because you're expected to be able to perform those duties to your client even without a written signed contract, but sometimes there are contracts as well. So, for example, because we're going to go through kind of an example to outline this, at the time of your relationship, a client could reasonably expect that you will keep treatment-related information confidential, that you will not disclose that. It's one of the duties. So the second element that would have to be in place is that the practitioner was derelict in that duty, so the duty to maintain confidentiality. And that occurred either through an action that they specifically took or by inaction. So for this confidentiality example, the practitioner accidentally or unintentionally released confidential information to a public welfare agency without the client's knowledge. So that would be considered an act of commission, even though it wasn't intentional. It was still an action that was committed. An act of omission would be more of if the client or if the practitioner left confidential information out on their desk and didn't put it away at the end of the night and left for the day, and a janitor came in and happened to read the person's confidential information, was able to obtain their social security number, information about their mental health, and then shared it with the rest of the janitorial staff, et cetera, that would be an omission because it was because of inaction, so not doing what they were supposed to do, which is lock their stuff up. Somebody else happened to access the information. So that would be kind of the difference between commission and omission, but it still is demonstrating that they did not follow through on their duty to maintain confidentiality. The third piece would be there has to be evidence that the client suffered some sort of harm or injury because of the practitioner's lack of maintaining their duty. So because for the situation, the practitioner accidentally provided confidential information to a welfare agency. So let's say that for this, it's for housing, and part of the clients need to be clean and sober to maintain their housing. Well, the case notes that they sent to the agency disclosed, happened to contain information about how the client went to a party and had a couple of drinks, completely regretted it, and hasn't done it since. Well, because there was content in the note stating that they drank, they lost their housing voucher, and now can no longer receive free housing, and they're going to have to figure out how to pay for it. The fourth element is that the harm or injury was directly and proximately caused by the professional's dereliction of the duty. So there has to be, so a client might suffer during the duration of a therapeutic relationship, but it doesn't mean that malpractice occurred. It just might be for whatever reason. So in order for it to be malpractice is that the harm or injury was directly related to the professional's action or inaction. And so you can see here, the client suffered financial injury because the social worker's unauthorized disclosure of confidential information. They lost their housing voucher, so now they have to pay all of their rent, but they are unable to because they're working on trying to find a job. So now this could result in eviction, money not being spent on medication because now they spend it on housing, et cetera, et cetera, et cetera. But it has to all tie back to the practitioner's dereliction of their duty. So those four things, they have to be in some sort of professional, contractual, legal duty relationship. The practitioner has to have done some action or inaction. There has to be evidence that the client suffered some injury or harm, and that that injury or harm is directly related to the practitioner's dereliction. So that is malpractice in a very quick nutshell. So if those four elements are in place, then the client or the client's family would have a case to make a formal complaint about malpractice. And there's four different ways that complaints can be made or kind of turned into. So the first one would be a complaint could be made to the state licensing board. It's important to note that it could happen, all four of these could happen, or just one of them. So for the state licensing board, you would make a complaint to whatever state the practitioner holds their license in. It is, when I made the report on my former employee who was having inappropriate relationships, I ended up doing a report. I think it was online. Then you submit it to the state. You have to have all your evidence. It's similar to a CPS type case, but mine was handwritten. I didn't talk to a person until they received it. Now that could have been made by me as an individual. It could have been made by the agency. It could have been made if the client believed that the relationship is inappropriate. The client could have made a report as well. So then, because you need your license to do many social work job duties in the state of Michigan, that could greatly impact the ability to get a job, keep a job, and perform your social work duties. So there is some implications. There's also fees and fines that are often associated with complaints that are substantiated, and so there's also a monetary piece that the social worker might experience as well. The NASAW is another place where you could make a report. Sometimes they will then report it to different agencies, so they might do it to the state as well. If the person is a member, they could lose their membership. That one doesn't have as many implications with being able to do the job. You don't need to be a member of the NASW for your job functionality, but the NASW does hold private practice insurance. So that would be if you were, if someone was someone was seeing a practitioner and they were doing private practice and that's who held their malpractice insurance, that would be a route to explore. There is the civil court and there's criminal court. So civil court is more of the lawsuit. Criminal court is more towards like the felonious activities and more associated with law enforcement. So the thing that's really important to know, in criminal trials, you kind of have that you're innocent until proven guilty. Same thing with civil suits. There has to be an investigation to make sure that whatever is being brought up is actually occurring and it's not just somebody maliciously accusing their social worker of something because they didn't like their services or didn't like the outcome. So where it differs from criminal court of law is it is not, you have to have no reasonable doubt. There just has to be preponderance of evidence. And so what that means is that the evidence to support the case has to be stronger than the evidence to not support the case. So it doesn't have to be 100% provable. There just has to be the majority of evidence to show that this likely occurred. This is also the case with licensing boards in regarding to violations of the licensing standards. So that's just something that varies a little bit different from like the criminal cases that you see on TV, all the sensationalized ones. It just has to be the preponderance of evidence, not 100% provable. So that's all taken from our good friend Frederick Reamer as well. All right, 3 types of malpractice. There's malfeasance, misfeasance, and non-feasance. I think the one that we think about a lot when you hear malpractice is that you've intentionally done something wrong. You've slept with your client, you've stolen from your client, you pushed your client, those types of things. Those fall under malfeasance because those are intentional actions. But it's important to know that misfeasance and non-feasance also exist because these are the ones that I think even those with best intentions might fall under. So malfeasance is the intentional action, so it's the active commission actually doing something. Usually involves some sort of intent to harm or malice, and it may constitute criminal behavior. So examples of this would be if you were embezzling your client or donor's funds, providing services out of your scope of practice. So if I have not been trained in EMDR, I can't provide that type of therapy to my clients because I might cause them harm. It goes against the duties of care that are outlined in the Code of Ethics. If you're sexually harassing your client or even people within your agency, that all does fall under types of malpractice. That is considered malfeasance. Misfeasance is making a mistake in the application of an acceptable practice. So this really doesn't mean that you're doing something out of malice or intent to harm. It just demonstrates more of negligence or potential carelessness in your practice. But it is still considered an act of commission because it's something that you've done. It just doesn't have that intent to harm behind it. So an example would be if you disclose confidential information in error. We had a case where there was 2 people in our clinic who were dating each other. They kind of had a tumultuous relationship, so sometimes they had release of information signed for each other, at times that they didn't. Well, it happened to be at one of the times where they didn't have a signed release active. The girlfriend called up and wanted to know the appointment time of the significant other. In error, the person gave that significant other the appointment time. Well, that was considered a breach of confidentiality. It wasn't necessarily intentional, but the girlfriend was like, I caught ya, and ended up filing a complaint for breaking confidentiality. There wasn't huge consequences because of the situation and lots of factors, but we did have to do disciplinary action for the social worker because technically that was a breach of confidentiality. So example, that was the disclosing information. Forgetting to get a signature for services can be considered one. Again, things that you're not necessarily meaning to do, but if your funding is dependent on a signature and you didn't get it, considered malpractice. Non-feasance is making a mistake in the application of an acceptable practice. Again, that entails negligence and carelessness, usually an act of omission. So failing to follow up with a client. Let's say they left you a message on your phone saying, hey, I'm going to harm myself. I'm going to complete suicide. You get distracted, don't call them back right away, and they end up completing that's considered nonfeasance and malpractice, even though you didn't intend to